Does the defense have a motion?
You seated?
So, Your Honor, we would move for a judgment.
I can't hear you. Is that microphone on?
I think it is.
Okay, either you're too tall or it's too short, one or the other.
Your Honor, at this point, we would move for a judgment of acquittal. Based on the facts presented in the state's case, no reasonable jury would be able to find Ms. Jewell guilty of the charges. Specifically, the first charge, manslaughter by culpable negligence, the state's burden was to prove culpable negligence. That standard is a gross and flagrant character, evincing reckless disregard for human life or the safety of persons exposed to its dangerous effects, or the entire want of care that would arise the presumption of indifference to the consequences, or such wantonness or recklessness or grossly careless disregard of the safety and the welfare of the public, or that reckless indifference to the rights of others. Further, as the jury instruction states in the case law indicates, Ms. Jewell would need to consciously follow a course of conduct that she knew or should have known would likely result in death or serious bodily injury. The state has not presented evidence that this was a conscious act by Ms. Jewell to leave the child in the car. I've talked about this case in previous motions. It's Kish v. State, 145 Southern 3rd, 223. That's Florida's first DCA. It was out. Holding was in 2014. In that case, a mother changed her children's bus route from her home to the father and the stepmother's house. Unbeknownst to that mother, the children were ill and they would be unsupervised when they got to the house. There was a trial on that. The children became very ill. The state charged her with aggravated child abuse and culpable negligence, a misdemeanor. In that case, it was a bench trial. The first DCA reversed the trial court who found her guilty of culpable negligence. Their reason for doing that was because she had no knowledge that the children were ill. She had no knowledge that they would be unsupervised. And without that knowledge, it can't show a reckless disregard for the safety of the children. In this case, the state presented significant evidence that this was not a conscious choice. The testimony of Ms. Purchell, that Jewell told her that she forgot the children, forgot that the child was even with her. That video that was just played indicates the same, that she lost awareness of the child, not that she made the conscious choice to leave the child in the car and go into the house. Just one moment. In addition, Ms. Paige testified that she was the one that loaded Ariya into the car, put the diaper bags and everything back there. There has been testimony of things that could have distracted Ms. Jewell that has come out in the state's case. And for those reasons, we don't believe that this was a conscious choice, and we don't believe a jury would be able to find that this was a conscious choice. In addition, culpable negligence, it's not just considering what happened on this day. We would need to look at the totality of the circumstances. That's the history that Ms. Jewell had with the child, the history with the family, her history of care. There's a couple cases that talks about that. One is Getsy v. State, 193 Southern 2nd, 679 out of the 4th DCA from 1966, and Tipton v. State, Florida Supreme Court case, found it 97 Southern 2nd, 277. In Getsy, it's a man that was playing with a loaded firearm around his wife that he had got for Christmas. I believe he had been drinking. He was playing with the hammer of it, sat down on his wife's lap, and accidentally shot her, killing her. When the court evaluated that case, they looked at his care for his wife, their history together and whatnot, and found that this one isolated incident was not enough to show a reckless disregard for the safety of his wife. Similarly, there's Walsingham v. State, that's 272 Southern 2nd, 215. I believe it's a Florida Supreme Court case out in holding on 1973, that a father shot his child with a gun after he'd been consuming some alcohol. There was testimony presented that the child was very close with the father, and that was not found to be culpably negligent. So in this case, the state's witnesses explained that Ms. Jewell was an exceptional babysitter. She regularly played with Ariya during the course of the time that they were together. The parents never had any issues with Ms. Jewell until this incident happened. In fact, they sought her out to ensure that she could be the babysitter. She has significant ties to that family. They were extremely close. She went to family gatherings and whatnot before she was a babysitter. And both parents agree that Ms. Jewell, prior to that day, took exceptional care of Ariya. In addition, looking at the evidence that was presented of her demeanor when law enforcement arrived, she was extremely distraught, was crying uncontrollably. Ms. Paige testified when Mrs. Jewell realized that Ariya was still in the car, rushed towards the car, threw her out of the way to try to get into the vehicle. We understand that 5 hours of being in a motor vehicle is a very long time for a child, but the state's expert testified that this death could have occurred within 20 or 30 minutes. So all of these factors the court needs to take into consideration when determining whether this is culpably negligent or not. And the jury would need to take that into consideration too. And given all of the factors at play here that indicate Ms. Jewell regularly provided the care that this child needed, given her demeanor and the history, I don't believe a reasonable jury would be able to find that her conduct on that day rises to the level of culpable negligence. The state's theory here seems to suggest a results-driven analysis that is not, does not comport with the law. It is a very sad event that happened. People can die and it not be culpable negligence. So for that reason, we believe the count one has not been proven, and the court should enter a judgment of acquittal on that count. As for the count two felony murder, this felony murder was predicated on leaving a child unattended in a motor vehicle, which we have a motion pending to insert a mens rea into that. But if a mens rea is not inserted, that would be basically a strict liability felony murder, which there's a case, Mahan v. State, it's 377 Southern 2nd, 1158, Florida, 1979, out of the Florida Supreme Court. In that case, it talks about the constitutionality of felony murder, and specifically it states that felony murder is constitutional because the intent for the underlying felony will transfer up to the murder. In this case, without an intent element, there is nothing to transfer, which indicates that this is probably not a correct felony to predicate for felony murder. One moment. Here, the state hasn't provided any evidence that Ms. Jewell even intended to leave the child in the car. I don't believe that there's any intent to transfer, and I think that is problematic for the felony murder charge. In addition, this would effectively bootstrap felony murder to a strict liability crime, which is not does not comport with the jurisprudence. As far as predicating it on leaving a child unattended in a motor vehicle, there's a couple cases that evaluate felony murder in Florida compared to the New York statute. One of them is State v. Studevant, 94 Southern 3rd, 434, out of the Florida Supreme Court from 2012. In that case, it discusses aggravated child abuse, but it indicates that because it is one of the enumerated felonies for I think it's subsection 3, that this is largely allowed. But when evaluating the New York statute, it talks about when there is an unenumerated crime charged as the predicate, and the death is directly tied to the crime and not like a collateral consequence of it. In instances such as that, felony murder may be inappropriate based on Studevant and Robles v. State, 188 Southern 2nd, 789, Florida Supreme Court, 1966. I have not found a case that specifically addresses this situation with a unenumerated felony that is strict liability and its ability to predicate felony murder. But based on the holdings in these two cases, I don't believe that is appropriate, nor do I believe that it can be a predicate because there is not a mens rea associated with that crime. So for that reason, we would also move for a judgment of acquittal on the felony murder. If I can just have one moment. Further, we would move for a judgment of acquittal on count 3 as well. We have filed a motion in this case explaining our belief that it requires her to knowingly leave a child in a car based on the plain language of the statute and the jurisprudence. So for that reason, there has been no evidence presented that indicated that this was a conscious effort on Ms. Jewell's part to leave the child in the vehicle. And without that, count 3 has not been proven. So we would ask the court to move grant an acquittal on counts 1, 2, and 3.
Okay. Anything else?
That's all I got.
State?
Thank you, Your Honor. Taking the facts in the most favorable light to the state has shown a prima facie case as to counts 1, 2, and 3. Starting first with count 1, Taylor v. State, 363 Southern 3rd, 126. It's the first DCA 2023 is the controlling case, and it discusses the jury instructions. Namely, it states culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Your Honor, the state has put forward the facts sufficient to have this case go to the jury. The defense seems to argue that phantom elements adding a level of intent as to both counts 1 and 3. I would cite Leet versus State, 595 Southern 2nd, 959, 1991 from the 2nd DCA. And this was a case involving culpable negligence. And in that case, they said that culpable negligence is not a common law theory of criminal intent. It is an objective standard. Thus, in that case, it was not essential for the defendant to have actual personal knowledge of his omission that would lead to death or great bodily harm. So it's an objective standard. There is no conscious knowing required in this standard. And they finished the paragraph in that particular section by saying that it may sometimes seem harsh and may very well punish a defendant for a crime lacking mens rea. Nevertheless, it was the legislator's prerogative to select this objective standard for the use in child abuse cases. So as to count 1, in dealing with culpable negligence, the state has put forward sufficient facts that this needs to go to the jury to determine whether or not this was culpable negligence. It is an objective person standard, and the facts that have been put forth are sufficient to show that prima facie case. As to counts 2 and 3, this is not New York. This is Florida. And as to the grounds upon which it seems defense, again, is seeking to insert an additional element that the legislature has not required in order for it to be a felony under count 3. The way that this is charged is any other felony that is not enumerated, and that's in paragraph 4 of 782.04. Your Honor, there was no limitation by the legislature that would prohibit certain types of felonies. If that was the intent, they would have written it that way. So based on all the information, there is sufficient facts for counts 1, 2, and 3, namely that the facts that have been presented as to what happened on July 19th of 2023. The defendant remembered going to the house. She remembered everything that happened. This wasn't some medical episode, some amnesia, or some stroke, or something that would have precluded her from engaging in the duty she accepted. The jury has heard that she accepted payment to be the caretaker of this child, and now it's time for the jury to be able to determine whether or not this rises to the level of culpable negligence based on what they have heard. And then as to count 3, sufficient evidence and facts have been put forth that the child was left in the vehicle. The defendant admitted she left the defendant in the or the victim in the vehicle, and that it was for over 15 minutes, and then the resulting harm thereof. So based on the legal standards before Your Honor and this court, the state has put forward a sufficient case, and we would ask the court to deny the defense's judgment of acquittal request.
Okay, defense rebuttal.
Your Honor, I would just point out the Lees v. State case that the state cited. There we go. I don't believe that is correct. First of all, it's out of the second DCA. I don't believe it's binding on this court. And the Leeds case would directly contradict the first DCA's holding from the Kish case in 2014, mostly because if this objective standard in consciousness was not applicable, then the opposite conclusion would be reached in Kish, which it is not. So for that reason, we would stand by our previous arguments.
Thank you. Okay, with regard to all 3 counts, I do find that each of those counts does present a question for the jury. So at this time, the motion for judgment of acquittal at the close of the state's evidence is denied. Is the defense ready to go forward at this point?
Yes, sir. We have some witnesses that we called. I think the court had ruled back in September they may not be allowed, but we need to proffer that.
Okay, why don't we, how long is this proffer going to take?
I think there's 5 of them total, Judge. So
What are they supposed to testify? What was their
they're
testimony?
going to testify. They've known Ms. Jewell for some period of time.
Character evidence.
She's watched their children.
Character evidence.
Well, of course, the conduct as well, Judge, as far as we're concerned. But yes.
Well, okay, bring them on. Let's do it.